So I am Catalin Stefan Popa. I am the manager of this program dealing with the culture of law in the history of Levant and the Middle East within the Institute for Advanced Studies in Levant Culture and Civilization here in Bucharest. This is our third meeting within this lecture series organized by our institute. The lecture series is devoted to the cultural and legal diversity of the Levant and the Middle East. The second conference was focused on the codification of Jewish law. From Jewish legal sources, we move today to Islamic private international law. And we have the pleasure of being introduced in a comparative scholarship of Islamic and international law. I have the special pleasure to welcome this evening Professor Mohammad Fadel from the Faculty of Law of the University of Toronto, Canada. He's an expert in the fields of business corporations, economic analysis of law, international law, Islamic law. He wrote his PhD dissertation at the University of Chicago and received his GD from University of Virginia School of Law. Professor Fadel was admitted to the Bar of New York in 2000 and practiced law with the firm of Sullivan and Cromwell in New York. Professor Fadel has published numerous articles in Islamic legal history and Islam and liberalism. Thank you so much, Professor, for accepting our invitation. Now you have the floor, and after your lecture, we have some minutes for question and answers regarding your lecture.
Thank you so much, Catalin, for that very generous introduction, and thank you for giving me the great honor to be able to present this workshop today. Okay, so this presentation is based off of a paper that will be forthcoming in the American Journal of Comparative Law that should be appearing this fall. And it's essentially an attempt to defend the integrity of the idea of something called Islamic international law. And so I want to place Islamic international law within a broader comparative context and historical context of the history of international law globally. But to do that, first you have to defend the idea that there is a coherent body of law that is international in a significant way in Islamic legal history. And that's basically what this paper is trying to do, right? So it's trying to do two things. First, it's trying to defend the idea of the intellectual coherency of the idea of Islamic international law. And second, it's trying to place this history in a larger global conversation about international law. So when we talk about international law today, there's the conventional universalist approach, which just basically views contemporary international law as universal, representing universal human reason, and its descent from Europe, notwithstanding, it nevertheless is essentially universal. There are increasing challenges to these claims of universality of international law. I want to highlight two particularly influential strands of challenges to these. The first is known as TWAIL, which is an acronym for Third World Approaches to International Law. And the second is known as Comparative International Law. The first approach, TWAIL, seeks to undermine the universal normative claims of contemporary international law, often by challenging its claims to represent universal rationality and humanism by exposing what it sees as contemporary international law's essential ties to European imperialism. In other words, TWAIL seeks to argue that imperialism was not incidental to international law. It was, in fact, part and parcel and part of its essence, so that you can't really separate imperialism from the whole project of contemporary international law, right? So it ultimately strikes at the legitimacy of contemporary international law. The second strand, known as comparative international law, emphasizes instead that different states, different modern states, have different traditions of international law. And these different traditions coexist in the contemporary world order. So the United States might have its own distinctive interpretation of what international law requires. And for that matter, Russia might have its own conception of what international law requires. So rather than having a universal, rather than international law functioning as a universal body of law, in fact, what you have is multiple systems of international law coexisting with one another, right? Sometimes they overlap, but sometimes they differ on fundamental points, even with respect to something that is thought to be the pillar of the post-World War II international order, namely the permissibility of the acquisition of territory by force, right? So the comparative international law scholarship also challenges the universality of, or the universal claims of international law by pointing out the fact that different states have different traditions of international law, okay? So where does Islamic law fit in this? Well, whatever approach one takes toward Islamic international law, I mean, so some people try to associate Islamic international law with TWAIL, right? So some TWAIL scholars will point to Islamic international law as a resource for oppressed peoples in the global South that enables them to resist imperialism, right? Other TWAIL scholars will look at Islamic international law as a resource for peaceful interaction in the global South, right? Scholars from the comparative international law school, on the other hand, would like to emphasize the fact that Muslim countries might have distinct approaches to international law. For example, you find that many Muslim countries include a Sharia exception to certain human rights conventions, right? So certain kinds of conventions, such as conventions on the right of the child, convention to eliminate discrimination against women, many Muslim countries, when they ratify these conventions, will append to it an exception, saying that we will abide by these conventions to the extent they do not contravene Islamic law, right? And then finally, there's something what I call the historical approach to Islamic international law, which is just sort of an attempt to unpack the history of Islamic international law for the sake of understanding it, have a better scholarly understanding of it. Now, that's what I'm arguing is that's what I'm trying to do in this paper. I'm trying to take a historian's approach to Islamic international law and not really taking a stance on whether it's an appropriate source of TWAIL or for comparative international law, right? But what I do want to emphasize is whether we want to view the historical tradition of Islamic international law from the lens of TWAIL scholarship or from the lens of comparative international law scholarship, a better understanding of historical Islamic international law is indispensable, right? So good historical scholarship will serve everybody's interests. This paper seeks to do that by closely reading how classical Muslim jurists analyzed cases involving what contemporary lawyers today would call private international law, right? i.e. cases involving the status of persons and things. I argue that when we do so, several important features of classical Islamic international law become clear, right? First, we realize that in classical Islamic international law, the idea of sovereignty is central to legal order. Sovereignty, as far as I can determine based on my reading of these sources, consists of four elements: a specific territory, which they call dar, a capacity for self-defense, which is in Arabic mana'a. This produces what they call secure possession. Sorry, it shouldn't be position, possession. Ihraz, meaning that property and things are protected. And then that produces the last thing, legal inviolability, right? So having a territory, having the capacity for self-defense, and having security, right, then allows for the existence of a legal order to arise, the result of which is that there is inviolability, isma, right? The technical term for which. Now, from this perspective, law is inherently territorial. Because it can only operate within a specific territory, right? Okay, so sovereignty then is the precondition of all legal order, whether it's Muslim legal order or non-Muslim. Sovereignty is a combination of the brute social facts of power combined with commitment to follow a common system of law, even if that law is no more developed than accepting the decisions of a specific person as binding. Sovereignty can only come into existence when individuals choose to come together for purposes of common defense and agree to submit to a common rule. For classical Muslim jurists, common religion was insufficient to establish a sovereign legal order because religion is subjective. As a result, it only binds the believers in that religion. Secure possession, by contrast, is the result of sovereign control of a territory, and it is manifested objectively in a manner that is incontestable without regard to religious belief. While common religion might secure what Muslim jurists call moral inviolability, only a sovereign legal order produces legal inviolability for persons and things. Now I want to switch a little bit to secondary scholarship on Islamic law. And here, the work of Majid Khadouri is especially crucial. He essentially invents this field in English language scholarship, English language legal scholarship. His role is so prominent that some contemporary scholars have called him the gatekeeper of Islamic international law, because if you want to write about Islamic international law, you have to go through Majid Khadouri's work, and for various reasons, which I'll get into, he was extremely influential, right? He was one of the earliest and most prominent of the English language scholars of Islamic law in the United States. He was a prolific scholar and teacher. He published numerous books on Islamic law, Middle Eastern politics, and Middle Eastern legal systems. His first book, War and Peace in the Law of Islam, was a history of Islamic international law. And his second book, The Islamic Law of Nations, Shaybani Siyar, is a critical edition of a chapter of positive law of an 8th century text, along with a translation and an analytical introduction. Now, Khadouri adopts a reconciliatory approach to his writings on Islamic international law, the structure of which is as follows. Islamic international law begins as a faithful reflection of a universal religious impulse to unite humanity into a universal Islamic state. When that goal proved difficult to achieve, temporary states of peace were recognized out of necessity. All pretenses to an international law based on Islamic religious universalism, however, are abandoned in the post-World War II international order by virtue of the Muslim majority states joining the United Nations. Reconciliation in Khadouri's analysis is achieved by dissolving any contradictions between historically articulated norms of Islamic international law and contemporary international law. Historical doctrines of Islamic international law are not interesting in themselves in Khadouri's analysis, but are only there to demonstrate the evolving nature of Muslim understandings of international law and the ultimate successful assimilation of Muslims in the contemporary liberal secular legal order. Despite the centrality of sovereignty and the foundational role that concepts of such as capacity for self-defense, territoriality, and secure possession play in the classical tradition of Muslim juristic thought, Khadouri scarcely pays any attention to these concepts in his analytic writings on Islamic international law. He instead emphasizes the primacy of religion as the basis for understanding classical Muslim international law, and asserts that international law, if it existed at all, was a stopgap emergency measure on the way to establishing a universal Muslim commonwealth based on religion. Indeed, he argues that there is no conceptual difference between quote-unquote internal Islamic law, i.e. the law that applies in the Muslim commonwealth, and Islamic law outside the Muslim commonwealth, saying that, quote, Islamic law of nations is simply the Sharia writ large, unquote. As my reading of classical and international Islamic law will try to show, however, religion, while not insignificant, is subordinated to the logic of sovereignty and the objective character of legal order, and that international law is distinguished from internal Islamic law insofar as it is law that is derived either from the primordial customary law of war or the positive agreements of equally sovereign legal entities. So what are the sources that I look at? My paper is based largely on the work of jurists from the, who originally were based in Iraq in the 2nd Islamic century, 8th century, the Common Era, and then their successors in Central Asia. They subsequently became known as the Hanafi school of law, right? And so you guys are in Eastern Europe, and so you should be familiar with the Hanafi school of law because that was the school of law that prevailed in the Ottoman Empire, right? So the primary figures that are form the data for my analysis are this fellow Muhammad ibn Hassan al-Shaybani, who died towards the end of the 2nd Islamic century, beginning of the 9th century, the Common Era, and then a great synthesizer of the Hanafi tradition from Central Asia, present-day Uzbekistan and Tajikistan, a fellow named Muhammad ibn Ahmad al-Sarakhsi, who died toward the end of the 5th Islamic century and the end of the 11th century, the Common Era. And then Burhanuddin al-Farghani al-Marghinani, another Central Asian Hanafi who died like about 100 years later. Now, why is the Hanafi school so central? The Hanafi school, I think, is very important because they've always been associated with imperial Muslim states. So at the time that Shaybani is writing, you have the foundations of the Abbasid Caliphate being established. The Abbasids are engaged in a project of centralizing the judiciary, and the Hanafi jurists, like Shaybani, are eager participants in that project, right? So Shaybani, for example, served as a senior judge of the Abbasid Caliphate, and so in addition to being a scholar, he also worked in the Abbasid bureaucracy, judicial bureaucracy. Shaybani wrote numerous works of law, so I'll just point those out very quickly. First, he has an encyclopedia of the law, which is called Kitab al-Asl, which covers the law from A to Z, so to speak. And in that book, there is a chapter on, what Khaduri calls the Islamic Law of Nations, a seria, and that's the chapter that Khaduri translated, actually. But then he has two specialized works on the seria. One is called As-Siyar al-Saghir, the shorter work of seria, and As-Siyar al-Kabir, the longer work of seria, right? The shorter work has survived, and it has recently been edited and published. The longer work has not survived in independent form. However, it was incorporated in a commentary authored by Sarakhsi, and that work is known as Sharh As-Siyar al-Kabir. Now, there is quite a lot of controversy about this commentary in terms of its provenance. Without getting into all the details, it's not quite clear where the text ends and the commentary begins, right? So the present day printed edition, the editor is very, very confident in his ability to separate the base text from the commentary of Sarakhsi, but many other scholars are not so sure. For purposes of my paper, I treat the commentary on the lengthy seria to be a synthetic work, representing the longue durée of Hanafi thought on Islamic law. So I'm not really concerned about any historical uncertainty in attributing particular doctrines to Shaybani. What's important to me is the conceptual ideas presented in the work. And then finally, there is the work of Al-Marghinani al-Hidayah, which is a consolidation of Hanafi doctrine, which was very influential. It formed the basis of Anglo-Muhammadan jurisprudence in India when the British were there, etc. Right? So these are all very central texts to the Hanafi tradition. Okay, so the first thing we want to look at is how these Hanafis understood jurisdiction, right? There are three basic jurisdictional categories. There is Dar al-Islam, which I translate as the Muslim Commonwealth. There is Dar al-Harb, which I translate as enemy territory. And then there's this third category, Dar al-Muwada'a, non-Muslim territory at peace with the Muslim Commonwealth. Right? Now, how do we understand these categories? For Khaduri, this jurisdictional division is empirical. There is the Muslim Commonwealth and there's everything else. For some reason, which I don't understand, he doesn't discuss at all the existence of the third category, Dar al-Muwada'a, even though it is expressly used by the jurists that whose writings he analyzes. Now, according to Khaduri, the Dar al-Harb's existence is just a temporary feature of the world, a kind of state of exception that is resolved as non-Muslim territory is either converted peacefully to Islam or reduced to the status of vassals or are annexed to the territory of the Muslim Commonwealth. Another reason Khaduri understood these jurisdictional categories to be empirical is that he understood Islamic law to be a kind of universal natural law system, akin to the Roman jus gentium. Accordingly, non-Muslims' law have no standing in itself, and they are subject to the rules that Muslims believe oblige them. From Khaduri's perspective, the Dar al-Harb only comes into existence after the Muslim Commonwealth comes into existence, and therefore it is necessarily contingent on its continued resistance to incorporation into the Muslim Commonwealth. Likewise, on Khaduri's analysis, if the Muslim Commonwealth would disappear, there would be no such thing as a Dar al-Harb. Now, I have a different interpretation of Dar al-Harb. I believe that Dar al-Harb represents the primordial pre-political human condition, right? So the Dar al-Harb in Muslim juristic thought, in my analysis, is more akin to what Enlightenment era philosophers would call a state of war. So that there's a natural state of war, that the default condition of humanity is a state of war. Why is that? Because in Muslim theology, you have this concept known as bara'atul dhimma, the absence of obligation. According to this theological doctrine, human beings come into this world absolutely free, meaning they're not bound, they're not obliged, they don't owe any duties to anybody else, right? So we're born into the world having absolute natural sovereignty. And because all of us have absolute natural sovereignty, right, we have this propensity to then fight, okay? But we're also born into this world with a capacity to undertake obligations. Even though there are no natural obligations, we have the capacity to create obligations. And that capacity is represented by the idea of dhimma. Dhimma is a kind of psychological disposition of the human being that allows a human being to undertake obligations towards others, including an obligation to live in peace in a particular polity. So states come into existence by an act, a positive act that unites individual wills around the goal of creating peace between and among them. So by binding their dhimmas together, a group of people can create a sovereign legal order that can protect property rights and provide security to the person. When they do this, they establish a state of peace internally, but the state of war continues as between different polities, right? So the default relationship, because of the sovereignty of each polity, is that of war, right? Just as individuals, the default relationship among individuals is that of war, so too the default relationship between and among different political orders, different legal orders, is that of war, right? Peace, from this perspective, whether internal in a particular territory or internationally between two or more states, always requires a positive act of will, right? It's not natural. So war is natural, peace is constructed, right? So how is this manifested in the rules of Islamic law, right? So according to my analysis, right, law is territorial, right? It's a function of a particular legal order that exists in a specific territory. So this manifests itself in discussions of particular cases. So suppose the enemy raids Muslim territory, crosses the frontiers, seizes property and persons during this act of aggression. But the ruler successfully prevents them from returning to their territory. He captures them on Muslim territory. In that case, Islamic law treats them as the equivalent of usurpers. And it doesn't matter whether they convert to Islam or become vassals of the Muslim Commonwealth on Muslim territory. In this hypothetical, the ruler is required to restore the property to their true owners for free. They don't have to pay anything to get their property back, and the captives that the enemy seized on Muslim territory are liberated, right? They were free people to begin with. They were captured and imprisoned. Now they're free. However, if the raiding party makes it back to their territory with the property of Muslim nationals and Muslim nationals as their captives, right, it becomes their property. As a result, they can then import it into Muslim territory and sell those goods in markets in the Muslim Commonwealth, right? The captives that they took, the Muslim nationals that they took, whether they're Muslim or non-Muslim, upon their return to Islamic territory, they are liberated. They're not allowed to keep them as slaves, but the non-Muslims are required to receive compensation for the value of those captives. Now, the same territorial logic applies to the Muslim army when it is campaigning in enemy territory. Any booty that it captures cannot be converted into personal property rights as long as the army is campaigning on enemy territory, right? It's only when they return to Muslim territory with the booty can it become converted into personal property rights belonging to particular individuals. Now, the same rules apply to non-Muslim states. This isn't an Islamic rule. The same principles apply if two groups of non-Muslims are at war. So Shaybani uses the example of Byzantines and Turks. So this is Turks in the 8th century before they're Muslims. So Turks invade Byzantine territory and make off with goods and persons. If the Byzantines convert to Islam while on Byzantine territory, Islamic law deems them to be free, even if the Turks carry them back to Turkish territory. If the Byzantines convert to Islam only after they arrive in Turkish territory, but they convert before their masters convert to Islam, and if they manage to escape to Muslim territory, they are free by virtue of Islamic law's recognition of them as free, right? If the Turks, while still unconverted, lawfully import their Byzantine Muslim captives into Muslim territory, right? The Byzantines, however, would be slaves. This is on the assumption that they only converted to Islam after arriving in Turkish territory, right? If the Turks convert to Islam on their territory, and then their Byzantine captives convert to Islam, they would remain slaves of the Turks under Islamic law, under all circumstances. So conversion to Islam results in limited recognition under classical Islamic law. Most importantly, it confirms the status and the possessions of the convert at the time of conversion. When the Greeks converted to Islam on their own territory, they were legally free persons under Byzantine law, even if they were captives of the Turks. Their conversion to Islam while free persons renders them free under Islamic law, no matter what subsequently happens to them. If they convert only after arriving in Turkish territory and the Muslim Commonwealth is not at peace with the Turks, Islamic law will recognize them as free because of their conversion, provided they can make it to the territory of the Muslim Commonwealth on their own. If, however, their Turkish captors convert to Islam before the Greek captives make it to Muslim territory, Islamic law will recognize the Turks as their masters based on the fact that Turkish law had enslaved them. In this case, if they escaped from their masters and made it to the Muslim territory, the Muslim Commonwealth would be required to return them to their Turkish Muslim owners. The importance of these cases is that they established that as far as Shaybani was concerned, he was expounding on the legal implications of a universal common law of war that pre-exists the territorial law of the Muslim Commonwealth. Now, what about what happens when there is a state of peace? So peace means that possessions and status of foreign nationals and their property are protected under Islamic law. A Muslim court has jurisdiction over any disputes between peaceful foreign nationals that take place on Muslim territory, in which case Islamic law applies. A Muslim court, however, lacks jurisdiction over disputes of peaceful foreign nationals if the facts arose in foreign territory, unless they both convert to Islam or become vassals of the Muslim Commonwealth, and the dispute involves possession of tangible property or the status of a person. If these conditions are met, the Muslim judge applies applicable foreign law to the dispute, even if it is contradictory to Islamic law. So establishment of peace renders non-Muslim persons and possessions as inviolable as the persons and possessions of Muslim nationals, albeit only for so long as peace is maintained. Because this is a peace between sovereigns, Muslims are not permitted to apply Islamic law to the dealings of non-Muslims in their territory. But when they are lawfully present in Muslim territory and bring their disputes to the Muslim court, Islamic law applies by virtue of the law of the territory. Although Muslims are morally bound to follow Islamic law wherever they may be, when non-Muslims outside the Muslim Commonwealth convert to Islam, their property rights are determined solely by reference to local law, even if local law is repugnant to Islamic law. For example, if it deprives some heirs of a share of the decedent's estate relative to what Islamic inheritance law would provide them, or if the foreign law recognizes the effects of forcible conversion of property. The Muslim judge may advise the litigants in such a case, however, that as a matter of religious scruple, that they should return property to the plaintiff if Islamic law would so require, now that they are both Muslims. But the court would lack jurisdiction to compel the defendant to restore the property to the plaintiff. But does Islamic law apply extraterritorially? In a very limited set of cases, Islamic law can apply outside of the territory of the Islamic State. If the dispute involves Muslim nationals and the facts of the dispute arose out of conduct taking place in foreign territory, a Muslim court would exercise jurisdiction and would apply Islamic law over the dispute upon their return, with a few limited exceptions, primarily involving homicide and grievous bodily injury. The difference between the legitimacy of jurisdiction in this case and the lack of legitimacy in the prior case is that in this case, Muslim nationals, even though their dispute arose with respect to conduct beyond the territory of the Muslim Commonwealth, nevertheless had a pre-existing political tie to the Muslim Commonwealth. They had lived in it, right? And so they are abroad, presumably temporarily. That tie entails abiding by Muslim law in their mutual interactions, wherever they may be, insofar as each of them has standing under Muslim law for the protection of his life and goods. By contrast, Muslim converts, or non-Muslims who later become Muslim nationals by way of vassalage, don't have a political tie to the Muslim Commonwealth until they immigrate to the territory of the Muslim state, right? And so until they immigrate to the territory of the Muslim Commonwealth, they have yet to establish sufficient standing in order to have their extraterritorial claims enforced. So to conclude, the history of Islamic international law is still very much underdeveloped. There are a lot of sources that we haven't paid significant enough attention to, largely because of the dominance of the religion paradigm, right? I think when we look at Islamic international law purely from the lens of law and look at it as lawyers, there's a lot of doctrine that remains to be explored and discussed. The second point is that it's implausible to write a history of European international law as though it is a direct descendant of Roman law without taking into account European interactions with Muslim powers in the Mediterranean, beginning with the Crusades and continuing through the rise of international law in Europe. We just know that there was a huge amount of diplomatic interaction between Muslim states and European states. And one of the points that I want to sort of stress from our presentation of Islamic international law and recognizing the notion of Islamic international law as authorizing the creation of law between sovereigns is that treaties are themselves a source of Islamic international law. In fact, they are the primary source of Islamic international law. And so if we want to write a history of Islamic international law, we begin with the juristic writings, but then we have to supplement them with treaty law. Because just as we wouldn't consider ourselves to be knowledgeable about a domestic legal order if we only knew about its constitution and did not take into account its statutory law, the same principle applies to Islamic international law. It's of course crucial that we understand doctrinal works like the Siyar of Shaybani and the commentaries of Sarakhsi, but then we have to add on to that the lawmaking practices of Muslim states as embodied, manifested in particular treaties. So that's sort of the positive dimension of Islamic international law. And it would be implausible to think that this positive Islamic international law had no influence on developments of European understandings of international law, given the intense amount of interactions among Mediterranean peoples. Now, returning to where I began in terms of the criticism of Khaduri, classical Islamic international law, in my opinion, contrary to Khaduri's claims, was a conceptually coherent body of law distinct from Islamic domestic law. It established, among other things, the preconditions for the existence of legal order, as well as the limits of legal order, and most crucially, it authorized lawmaking between two different powers based solely on the terms of their express agreement, right? So it's a different kind of law than, for example, the law that applies to regulating the marketplace, right? Because the law comes from the agreement of two sovereigns, and therefore it, I think, satisfies modern conceptions of international law. So I will stop here and hopefully have enough time for discussion. Thank you very much.
Thank you very much, Professor Fadel, for this genealogical approach and very historical one in the understanding of what actually international Islamic law means. We have some questions. I suppose my colleagues have some questions, and myself, I took some notes during your presentation. First of all, I would like to ask you, I wonder if there are some mutual influences between the formation of Islamic law in Iraq, in Mesopotamia, and the canonical law of the Church of the East, because we know that during the Abbasid time, there have been some very well-developed legal sources in the Church of the East, in the Syriac Church in Mesopotamia. I can give you some examples. For example, one patriarch of this Church of the East, Patriarch Henanisho, composed an impressive book on the canonical law of his church. And I suppose it should be some relationship between what the legal system of Mesopotamia was in the 8th and 9th century, and then what was adopted actually in the Islamic legal system from this heritage, this Christian heritage, and I suppose from some Jewish sources as well. So do you see some kind of mutual influences from Christian to Islamic law, or from Jewish sources, Jewish legal sources to Islamic sources in the 8th, 9th centuries?
Well, I'm sure there must be. You know, part of what I'm trying to say is that Muslim jurists in the 8th century, like Shaybani, at least writing in the field of international, you know, calling it international law, right, assume that there's a common law of war, right? And that Islamic law as a moral system or as a domestic legal system, it might depart from it in certain aspects, right? But as a general rule, it accepts the fact that there's this there's this common law of war that exists among all peoples, right? Now, whether the church or the Jews have their own conceptions of these doctrines, I have no idea, right? I just don't know, honestly, right? I mean, so I think that it would be interesting to see whether canonists wrote about such issues. I mean, I think it would be a little surprising to me. I mean, my understanding of canon laws is primarily the law of the church. And so I don't know, you know, if they have a lot to say about, you know, what's the effect of armed violence. I mean, I just don't know. But certainly Muslim jurists accepted the notion that there was a common law of war that sort of everybody interacted on that basis, right? Now, Muslims had particular rules that applied to them, but these are like narrow exceptions to an already existing common understanding of what war is about, right?
Yeah, thank you so much. Just in addition to what was previously said, where is the Quran in this view, actually? Because in my view, the Islamic legal system starts actually not, and what was not based on the Quran, because the Quran was later formed and developed.
Well, I mean, the paper, I invite everybody, if they're interested, to read the paper. It's posted on SSRN. I can send the link. Paper, unfortunately, is very long. It's like 20,000 words. But without getting into debates about, you know, the historicity of, you know, the Quranic text, the Quran, in my analysis, and I discuss it in the paper, is very consistent with the territorial conception of law. So it has some explicit verses that assume not only that law is territorial, but also that the existence or non-existence of treaty relations affects the proper legal rule. So, for example, I'll just give the example I talked about in the paper. In Islamic law, if a Muslim non-intentionally kills another Muslim, there are two penalties. One is a religious penalty, penance. You have to perform penance. You have to like fast 60 days or free a slave or something like that. So that's kind of religious. But there's also a civil penalty. You have to compensate the next of kin. However, that rule only applies to Muslims who are present in Medina, in the Muslim Commonwealth. If the deceased was not in Medina, then whether you have an obligation to compensate the next of kin is going to depend on the treaty status of his people. So if this person was a member of an enemy tribe, a tribe at war with the Muslims, then there was no duty to compensate. But if he was a member of a tribe that was at peace with the Muslims, then there was a duty to compensate, right? So in my analysis, these concepts are implicit in some verses of the Quran already. The idea of territoriality and the idea of treaties altering domestic law, right? Both of those are present in the Quran.
Yes, thank you so much for this answer. Any other question? There is a question in chat. Just to see that there's a very long one. Should I read it?
Very long question.
Yeah.
I mean, what I would say, first of all, I'm a lawyer trained in the common law tradition.
Yeah.
So anything I say about Roman law, just take with a grain of salt. Yeah. Because I know nothing about Roman law and civil law, except the stereotypes that we learn as common law lawyers.
Yeah. Yeah.
So I tend to view classical Islamic law as being closer to common law insofar as Muslim law developed from a case by case analysis, so to speak. And so if you read these early works, they're always trying to find the answer to a specific case. And then what later jurists do is they try to abstract general principles from the solutions given to particular cases. And then when you apply them to new cases, you try to determine whether the general rule applies appropriately to this new case or not, right? So it looks to me very similar to the kind of reasoning we see in a common law system. But you know, I don't really know how civilian lawyers reason, so I don't want to go too far in that. So with respect to the last question, what role did the Ottoman imperial legacy play in the process of integrating Islamic law into the national legal system? Obviously, the Ottomans played a huge role, right? So Ottomans officially joined the Concert of Europe, I think in 1854 or something like that. I'm not sure. But even prior to that, the Ottomans had a lot of treaties with European powers, right? Not only in Eastern Europe and the Habsburgs, but also with Northern European powers and England. And so there's been a very, very long history of Ottomans engaging in treaty relations with Europe, which I think, you know, played an important role in, you know, paving the way for partial recognition of Islamic law into European ideas of international law. But, you know, that chapter of history still needs to be written. So a colleague of mine named Will Smiley has recently written a book, which was very interesting, about how, you know, the several hundred, you know, a century of conflict between the Ottomans and the Tsars led to important evolution in concepts of treatment of prisoners of war, right? So over a succession of treaties, captives stopped being viewed as slaves and became treated as a distinct category of prisoner of war, right? and this was developed over a series of treaties, right? So this requires, to answer this question requires a history of treaties, and not enough has been done on that.
Okay, thank you very much. I think after your lecture, we are much more optimistic about the place of the Islamic law within the international and especially the European legal systems. Thank you very much for this interesting overview of the concept of international Islamic law. If there are any other questions in the room or in the chat? There are no more questions. So many thanks once again for this privilege to have you as speaker within our lecture series devoted to the culture of law in the history of Levant and the Middle East. This was for us a great opportunity to connect each other, and hopefully we keep in touch and we have other opportunities of working together in the future.
Okay, thank you very much.
Thank you very much.
Okay.
We wish you all the best. Thank you.
Okay, thank you. Bye-bye.